We call in creator energy and all the forces for good to assist and bolster us in the addressing, corrections, remedy, and removal of hostility, ignorance, or evil. We feel the hand of remedy and justice at our backs, and we thank you. We acknowledge the hand of protection at our side, and for this and its continuance, we thank you. We do not give energy to risk and danger, but are instead buoyed by combined strength of knowledge and that of the people, our fellows. Where there is concern or fear, we turn to one another for support. Where there is doubt, there is goal and hope. When we encounter hostility or rejection, we prevail in the truth and knowledge we have combined into an unassailable force for good. Let it be so, and so it is.
Thank you, Charlie.
My pleasure.
My name's Ron Vroman. I'm the whole white man talking head for the Oregon Statewide Jural Assembly. We have Mike School here to talk with us. Come on, Mike.
You want me to just start with my story of the case?
Please do. Tell us what's going on.
Well, there was a homeowner that I've worked for off and on for a couple years up here, and she asked me to do a sliding glass door. And I had hurt my back, and I had taken on another job with Mountain Valley Properties to be the roving maintenance supervisor, maintenance man. So I told her that I really can't do your door. Please call somebody else. But she said that because of my reputation and my work ethic and skills, it had to be me. So I wasn't able to do the job. So I introduced her to a coworker, and she said that he could do the job as long as I helped him and supervised it, which I did. And he called me one day because I had given her an estimate, well, several estimates on one sheet of paper when I did the first job. So as I completed a job, she'd save up more money and have me do the next job that was listed on the estimate sheet. So the sliding glass door was job number 4, and it said $1,640 for a direct replacement customer supplied sliding glass door. But when we went to replace the door, we pulled the old one out and found that it had been installed improperly. So the entire framing was all rotted for over a 20-year span. So there was nothing to attach the new door to. So we showed her everything, and she asked us what can we do, and I said for 10 grand we can pull a permit and do it to code, or she said, is there another way? We said for 4 to 6 grand we can put it all back together and get it weather tight and guarantee a watertight seal. And she said, let's do that, and my daughter can fix it when she inherits the house. So because it went over, she fired us from the job after the door was installed and all the trim had been installed inside. So when I showed up to finish the job, all I had left to do was caulk the inside and then fix the floor and put the blinds back up when we were done. But she called an attorney after. So I went over to finish the job. She told me to get out of her house, refused to pay me, only gave me what was on the estimate because of all the rot and damage. The price of the job doubled because the materials cost and labor went up, and we had to pour concrete to pour a footing to set a plate in to be able to reframe the opening to set the door back in. But her attorney called the sheriffs and basically said that she paid me for a job, and I went back after the fact and asked her for more money because I thought the job was worth more, and that wasn't it at all. And I had filed an affidavit in the case originally in the first case, which was CU 000195, but it was omitted from the record by the judge, and they granted a restraining order against me in favor of her. And then that's when things started moving forward with this felony charge, which I originally filed a notice of plea and abatement because of defective service, and they sent the sheriffs out to arrest me. And they've been harassing me up here with this stuff, defaming me in the community, the newspaper. The sheriff shut down my neighborhood and were giving statements to all the neighbors that I was a fugitive felon flight risk. And I had to fire the court-appointed public defender in this because he was throwing the case, and it was obvious to me and everybody else involved. So we were documenting all of that with affidavits too. And when I finally got him fired in October, it took me, he was fired October 31st, and by law, he had 30 days to turn over all discovery. I still don't have half the discovery I should have. But what I did get from him on February 2nd was the audio. So this her name is Maria Rubalcava. She called the attorney who it appears her daughter works for, and her daughter got the attorney fired up, and he called 911 to initiate all this. So when I went before the jury in court, the jury was led to believe that this was a 911 call was made to the sheriffs, who responded and arrested me, and that's the basis for all this stuff. And that's completely a false narrative from start to finish. So the jury was misinformed at trial. My affidavits and records weren't given to the jury, and the jury was misinstructed and misinformed. And when the jury came back with a question on what makes the land claim fictitious, the prosecutor changed the narrative. The first one was that I don't know how to show you this, except put it up in front of the camera for a second. So this one shows on the bottom line. Can I turn it around?
Yeah, it's good. Go ahead.
Okay. It basically shows that I had to know the document was false when I filed it, which it's not false. So I was called back into court because the jury had a question on what is false and fictitious about the document. So the prosecutor removed this and changed it to mistake of law, in that even though he didn't know, he's still guilty because he violated the law, and you will find him guilty. So that's why I was found guilty.
Back up a minute, Mike. Would you tell us about the paperwork you filed, like a mechanic's lien?
Yes, I've filed statutory liens in the past, and this court has a history of removing them for other attorneys without giving notice, and that's happened to me twice with a lien that I filed against my former attorney, Joseph Zelmer. And the judge that did it, his name was S. Robert Tice Raskin, and he's the presiding judge of this facility. So I notified the jury during this trial that's why I tried the land claim, because it's in common law and superior to statutory law, which the attorneys control the record in statutory law. But the judge and prosecutor informed the jury that statutory law is higher than common law, and that I don't have any standing to do what I did.
What's the name of the document that you filed?
It's titled, I emailed it to you a few minutes ago. Let me dig it up. It's titled Notice, Declaration of Property Claim. Okay.
Maybe you can scan those and email them to me, and I'll have them in our record up here.
I do. It's the very most recent email I sent to you is the land claim.
I got one earlier today with 86 pages on it, Mike.
That was probably the sheriff's report from the thumb drive of discovery.
Okay.
And it has my affidavit in it.
Okay, I'll look at and see if I can find the land claim.
I sent you 3 or 4 total, but the last 2 was the claim of cognizance with the file mark from the court, and then the land claim.
Yeah, tell about the claim of cognizance also, would you?
I filed the claim of cognizance in court, so it was in the record. And then when I was the first day of trial, before the jury was convened, the judge had the bailiff hand it back to me and said they rejected it from the record.
You filed it into the court and they took it out?
Yes.
Yes. Charlie, did we mail one directly to the court or just to Mike?
We mailed one directly to the court, and I haven't been to the PO to see if we in fact have gotten the green card back.
Okay, so we've covered our bases the best we could.
Yes, I mailed it the same day that we made it, so we signed it.
All right, thank you.
Yeah.
So, Mike, what happened in the trial?
the judge declared me improper on the record when I claimed to be sui juris and asked the court to put that in an order. And then anytime I had an objection, I was required to just object. And then I had to wait till the judge motioned me into chambers with her and the prosecutor to state my objection. And then she would go back into court, get back on the record, and then deny the objection in favor of the prosecutor. So when I realized they were playing a game, I would take the document that I was talking to with me into chambers so the jury could see that I was carrying some type of evidence that wasn't being shown to them. And then when I came back out, the judge would still just deny it and omit it from the jury.
Are you paying attention, Michelle? This is what we're looking at.
Of course I am. Yes.
Yes. Do you have any questions for Mike? You two talk the same language.
Well, this is so, and I'm not certainly not minimizing your case, Mike, but this is so common. This is becoming more and more common, and you are educated and have experience in this realm. You've got to rebut every single thing and get onto the record that they are defaming you and slandering you and simply lying. And this is in a circuit court, correct?
No, it's a local superior court in Nevada County.
Oh, yeah. So it's just a little nothing court. I would be kicking it up to the next, they're just going to run you into the ground because that's what they do. Yeah. That's all they do. And it is all about games. Have you made it evident to the Nevada County Sheriff, the DA, police chief, all the actors? Are you copying everybody on these actions in this lower court?
Yes, when I got the initial letter from the DA compelling my appearance, and it wasn't a summons and complaint, it was just a prosecutor's letter direction to appear at the courthouse on a date and time, or a warrant for your arrest will be issued. So I emailed everybody, the board of supervisors, the sheriff, the court, the prosecutor, and notified them of my notice of plea and abatement, and that if they arrested me, it would be a false arrest because a response is an appearance, although an appearance is not a response. And they still arrested me. But it was their timing on it, because they arrested me 2 days before I had noticed them that I was moving this case to federal court. So they arrested me 2 days before the notice on the date I was going to transfer it to the federal court.
Okay, well, and are you in the midst of transferring that to the federal court? Or have you transferred it?
No, because with this felony, they've just destroyed my life and turned it upside down and bankrupted me. And with my health deteriorating, it's kept me in court for over 500 days where I haven't been able to get my hernia or back surgery. So it's just been kind of a mess. And with everything else going on, my cell phone got shut off. So I've been having time issues, money issues, health issues, and just trying to stay afloat, trying to figure it all out while they just continue to roll over me.
Okay. So, and I know I see your hand up too, Eric, but what I want to make really clear, and this is, and it's kind of, you've already attended, you've already gotten entangled with them. So it's kind of a moot point, but I do want to say that it's unfortunate that you started playing ball with them. These courts they have their own language, and they ignore the common law. The people, of course, they only deal with entities, your all caps name, and which is why I always, suggest, or I recommend that people do not step in to their courts, right?
Point of order here. Point of order here, Michelle.
Okay.
He refused to cross the bar, and they brought in deputies and forced him into the court.
Yeah. So it's all unlawful on its face. you did nothing wrong. You've gotten embroiled. So, and I'm really sorry to hear it. It happens way too much, and you've just got to keep yourself healthy and keep their feet to the fire. At the end of the day, it's a contract that it's null and void because of the corruption and the fraud, right?
Yes.
So you have to just take it all the way back to the beginning. And I understand your position. Again, I really feel for you. I'm dealing with my own situation, but I would personally be just calling them out, screaming it from the rooftops in writing, and not just email. You've got to create your court of record, through registered mail. That is super important for evidence because you're creating your evidence. So okay. You've got it all in writing.
This was registered mailed to the court. The judge had the bailiff return all my filings to me before the trial started. It was all removed from the record.
So they're really playing dirty.
I even occupied the office of postmaster on it with a red fox stamp, which nobody uses a red fox anymore.
Yeah. Yep, I see that. That's the 40 center. If there is any way for you to take action now into the federal court, and have you notified the U.S. Attorney's Office or anything like that? Do you have any paper trail?
Not to the U.S. Attorney, because the last time I tried to reach out to any of these people, they said we don't help criminal defendants and hung up on me.
Right, I know, and I've been down that road too with somebody else. But boy, there's just there is a lot you can do. It's time consuming, it's expensive, and of course that's what they try to do is break you, and that's where you're finding yourself. You're physically challenged and mentally exhausted, and I get all of that. There's a case that I'm working with where we took it above and I'll yield for a second, but we took it above to the Ninth Circuit Court, and they have decided that that her case will be labeled judicial misconduct. And so that's a separate, that's on a separate side. It's not with the Ninth Circuit. It's I forget. Anyway, it's the executive side, and you can't contact them. It's all done via mail, snail mail, and she is waiting for her case number to be assigned. Currently we are waiting for this case number to be assigned for judicial misconduct. So that's what I would, just because this is the path that I've taken, and it seemed to have rattled some cages and gotten some attention. And they're taking it seriously and labeling it judicial misconduct, which is exactly what's going on with you. It's all misconduct. So I'll yield. I won't. Yeah, I yield.
Thank you, Michelle. Brian, I saw you had something to say. And can you play the 2 recordings that you have so we can get them on this record? I yield.
And first of all, I would like to say that Eric's hand has been up for quite some time. Eric, can you speak?
Oh, God bless you, Michael. The system is rotten. You said you're in Nevada County?
Yes.
And that's in California, correct?
Yes.
And what city is nearest to that?
Grass Valley and Nevada City.
Okay. So you're on the western foothills of the Sierras then?
Yes.
Isn't that a pretty conservative area?
No.
No? Okay.
I mean, it was, but they've moved so many people up from the Bay Area liberals and gay people that it's changed the face of the community.
Yeah, this lawyer obviously has it in with his judge in some way, and I yield.
Brian, do you want to unmute your audio and talk to us and play your recording?
There we go. All right. Okay. Yes. Hi, my name is Brian Thomas Koth, and I'm talking to you from east of the Mississippi. I am a personal witness of Michael's school, character-wise, for the last 10 years. He's helped me with a lot of legal cases. We've bumped ideas and legal philosophy and doctrines off each other. And I've been watching from afar this case for the last 500 days, but I entrusted Michael because I know that he knows his stuff and he knows every move to do correctly in its entirety. And I've been watching this court of record, this very low level court of record, completely ignore his due process. It's even afforded at the common law, which obviously, as we all know, is statutory now. They don't recognize the common law. But even still within the boundaries of I've watched Michael try to, as he said, speak the same language as the judge asked him to, but she still was making it very difficult for him to do. I've noticed from the beginning, the nature of the arrest was done in violation of due process. There was never taken in front of the magistrate within 72 hours for him to face his accuser. The probable cause for the nature of the arrest was never held. He was never afforded proper lawful assistance of counsel. I personally watched it. I checked the record. It's not there. I literally watched these court puppets manipulate the record and what is it? Fox guard the hen house, gatekeep the record and manipulate it and exploit it to their favor, so to speak. Everything that Michael has tried to file has been in clean hands, good faith. So with that being said, when he told me that he was been deemed incompetent, I felt it was time to try to get a little bit more aggressively involved with this court of record out in California. And with doing that, I knew that my jurisdiction and my statutory reach and all that would be very, very difficult to try to breach it. But at least maybe I can enter the record and make some noise and let them know that Michael is being watched from the outside looking in under a status called amicus, under the court, and try to let them know, hey, I see what you're doing. Don't do it. But and they played little tricky games. They made me they allowed Michael to think he was going to be successful, and then the next hearing they took everything away from him. His opportunity to introduce witnesses, his opportunity to introduce evidence that would favor his innocence, they took all of that away from him. I witnessed this, and the reason I witnessed this is because Michael filed an affidavit. Again, going back to they had found him incompetent and they were going to mute him by appointing him a bar agent, fettered counsel, which violates his due process. And by doing that, that was going to strip the record of all his filings because, as you all know, when they statutorily put counsel in front of you, they take away everything he filed. So Michael fired that one, and he was going back in for the second, they were going to appoint him a new counsel. And I filed a brief, and he filed a motion or an affidavit stating that he was fully competent, coherent, could read, write, talk, walk, living man on the land, the whole 9 yards. And he particularly told the court of record that he wanted me with him as spiritual assistance of counsel. He was very particular with that language, assistance of counsel. So he told the court of record that he wanted me to be there as assistance of counsel. They, of course, denied that also. So that is kind of how I am involved personally with this CRK 000075. I started to investigate it and enter the record as amicus and assistance counsel, but I was denied on behalf of Michael because I don't live in the state of California and I don't have a license to practice law. However, I do live on Michigan, and I do hold proper knowledge of the law to, handle my own affairs. And I absolutely am entitled to offer spiritual assistance of counsel when anybody needs it. So there's no license that can be afforded to that.
Brian?
So how I am involved in this case with Michael. So I immediately reached out to the prosecutor, and to my luck, I was favored enough. I'm trying to dig it up here. Just bear with me as I get it. I don't know if you want me to play that initial conversation again where I said I was favored enough to get this on record, a conversation with the prosecutor.
Yes, please play it.
Let's see if this is it.
911. If you know your party's extension, you may enter it as
I believe this is it.
witness, press 1. For the truck EPA,
Can you hear it okay?
to speak with an operator, press 0 or remain on the line.
Yes.
Good morning, today's office.
Yes, good morning. How are you?
I'm doing well. How are you?
Good, good. Thanks for asking. Is Cambria forgive me if I'm not pronouncing the name right. Licenby?
Uh-huh.
Is she available?
Let me check for you.
Okay, thank
One
you.
moment, please. And may I tell her what case this is regarding?
Yes, ma'am. CR 000775.
And defendant last name, please?
School.
Okay. One moment.
Thank you.
You're welcome. Hi, this is Tammy.
Yes, hi, good morning. How are you?
I'm good. How are you?
Good, good. So my name is Brian Coth. I am a guidance representative, if you will, with Michael C. School, case number 00775.
I'm familiar with the case.
You're familiar with the case? All right, great. So as he was communicating some guidance and seeking some prayer, we all felt it'd be probably in the best interest of justice to maybe reach out and try to get, the state's side and position if there is something we can work out to where both parties are happy.
I believe he has an attorney at this point.
I'm sorry?
I believe an attorney has been appointed to represent him at this point.
Yes, and see, that's the nature kind of the call, because we've been following this quick case for quite some time, going on about 500 days. And we've observed that, Mr. School gets to go in, file some affidavits and evidence that favors his innocence to the record, and then somehow manages to get appointed counsel. And then counsel goes away, and he's got new counsel. Then he files more affidavits that favor his innocence. They are ignored. And just from the outside looking in, from an amicus, right? Questions are beginning to be raised as to what is going on. Because from the outside looking in, amicus, it appears this all started from a civil suit, and this may be some sort of retaliation.
The civil suit would have been Mr. School suing for work he'd completed and wasn't paid for. That was where the civil suit would have ended.
Right.
He took it to a point where no homeowner ever wants to go, and that is having somebody trying to evict you from your own home and filing a deed claiming ownership of that property. That's where the felony comes into play. That's why he's facing state prison. That's why he should have an attorney when he's telling the court that he is, quote, an idiot and doesn't understand the legal system.
Oh, right. Okay.
So yeah, because we have to protect our appeals here, and we don't want to do this case again and again because he's claiming he's a, quote, idiot and doesn't understand the legal system and he's facing state prison, we need to get a trained lawyer in here to assist him with his case.
Okay.
So
my question would be, am I going to have any issues trying to pull up transcripts from all the proceedings from Michael C. School has been present?
I can't answer that question. You can go to the clerk's office and see what they...
Because again, this sounds a little bit contradictory to some of the statements Michael C. School is making, some of the records we've verified that he's filed. But and some of the records that we're having trouble verifying is that the initial civil suit never appeared for a trial by jury. And it, again, looks like this is...
I'm not familiar with any civil suit
out
there at all.
Yeah.
I don't know. He just took it to an extreme immediately with the eviction on the homeowner and filing a deed claiming ownership and then threatening, if you don't pay me $30,000 within 90 days, you're out of your house that you own. Like,
right.
That's not okay.
He did express to us that he filed a common law administrative process that,
Well, you got to file. You have to comply with California state law. We are not in whatever realm that you're in or he's in. We are in California. We have state laws that you have to abide by. You got to file the right stuff.
with all due respect, we do understand that, but, well, we also understand that all authority is given by God through the Pledge of Allegiance of the United States flag, correct?
I'm not going to engage in your sovereign citizen stuff with you. I'm telling you what the California state law is and what you can do and what you can't do. He was
Sure.
entitled, if he thought he was owed money, he could have taken the victim to small claims court and asked for his $1,500 or whatever he claims that he was owed. But he didn't do that. He did something completely illegal, and that is why he's facing a felony offering a false document charge.
So it does sound like the state is interfering with the civil
It
process.
has nothing to do with the civil process. There was no civil process done.
Well, again, with no disrespect, and it really does sound like the state is decided to interfere with a civil issue between two parties, a contractor and a client who failed to pay a bill. And
I'm sorry, but if you own a home in this state and you think it's okay for somebody to come slap a deed on you and evict you from the home that you own, then sure.
well, I mean, of course not, ma'am, with all due respect.
That's not how it works.
Right. I mean, agreement. If you did not perform any work on my property, I would completely agree with you. You can't just come and slap a deed. However,
We're talking about a sliding glass door replacement, sir. A sliding glass door where a quote was given and then the quote doubled. That's what happened here.
Okay.
We're not talking about an added addition or something. We're talking about a sliding glass door replacement.
right, this evidence should have been presented to a jury in civil, right? Shouldn't the original?
No, you're not entitled to a jury trial in civil court, and I don't believe that he filed anything in civil court. He just simply went straight and claimed ownership of that home.
Right, that's where we're trying to just, get something worked out and mediated to where both parties can be satisfied and walk away from this, because it sounds like there's a lot of confusion from the outside looking in. Again, we're very familiar with how mechanical liens can take place, and they don't necessarily have to involve a state court. So it sounds like in nature, that's where this problem derived from. It sounds like a contractor performed work, whether you and I, because I wasn't there, and I'm assuming you were not there either. So we really I don't have the nature of that particular event in question. And I really don't think you do either. It doesn't sound like this is something a state picks up.
That would be all a civil issue.
Right.
That's all that we were talking about. This would be a civil issue.
Right.
That's
And
not what
so
we're talking about.
that's what, because we're looking at 500 days here of, just going back and forth. And I think both parties would really like to just find a remedy. Let's just wrap this up and make it go away and be done with it.
Well, if he stopped obstructing things every step of the way and not claim to be a, quote, idiot and not understand how the California legal system works, I think we probably would be in trial today.
Okay, so what can I respond back with Mr. School to try to mediate this?
He can cooperate with his attorney if he wants to try to resolve this case. He can cooperate with an attorney, somebody that can speak to me in plain English and not in whatever language that you all speak, and we can talk about resolution. But
Yes.
it's impossible when he's
Right.
suing me, he's suing everybody in my office. It's obnoxious. I would love for this all to go away.
Right. And forgive me, but just so you understand who I am, I'm with the nation in the kingdom of Salem, Melchizedek in the kingdom of God. I'm his minister. And there's a separation of church and state. It's not really a sovereign citizen, is what you mentioned. That's an oxymoron. But that's how my life is here east of the Mississippi. We have brothers and sisters across America.
Well,
And we love each other, right? And we try to do the best
School is not
that
somebody I can speak to.
with the freedoms that are the God-given rights that everybody has, right? Including you, right?
Right.
So we all pledge allegiance to the same flag, and there's nothing malicious, right? We're not a malicious nation, right? We all pledge allegiance, one nation under God, correct?
I would agree. I would disagree in that I think it's extremely malicious to evict somebody from their home over a sliding glass door.
And just for
that she bought herself.
yeah, right, and I completely agree. Listen, I mean, if there was no work performed, that's way out of line. It's fraudulent, right? Okay, I completely understand.
Even if there was work performed, you still can't do that. That's not how we operate in this country or in the state.
Right. Okay. Well,
she provided her own sliding glass door. He quoted her $1,500. He pulled out the door and said, "No, now you're going to pay me $3,500." She said, "No, thank you," and stopped. And that's why we are here where we are today.
Right. So, again, it sounds a little extreme, and maybe perhaps I can offer some guidance to Mr. School. Now, again, with my last conversation, he said he is no longer represented by an attorney. That he has a hearing tomorrow.
Now. He does have an attorney again, and I believe the court date is on Friday.
On Friday? Okay. All right. So, because, I mean, at the end of the day, we understand him to be a veteran, a disabled veteran, and he's just trying to live his last peaceful days here on the kingdom of God's earth, doing goodwill.
Had to go hire an attorney to get her title cleared. So this wasn't just like an oopsie daisy. This was, she didn't know how to spend all this money to try to get her title on the home that she owns cleared. So I don't know if you understand like the gravity of the whole situation.
Well, that's why I think that we need to look at the record, and we're going to pull a FOIA for this and try to get the transcripts, because he's showing a lot of documentation that he claims the court of record is ignoring that will exonerate him of these allegations. Like, for example, the victim here did not follow the proper procedures that were prescribed to her, and she defaulted on the notice. She blatantly ignored him and said, "Sue me if you can." And it looks kind of stinky from the outside looking in, from an amicus status, from public poll and opinion, looking at least the records he has provided and furnished to us. It's looking very, very stinky, like a stinky diaper, with no disrespect there. But maybe we're missing something, which is why we wanted to reach out. And
I don't. He does not make any sense.
Right. Okay.
I mean, I've gotten, I think, 1099s from him for $20 million. So I'm sorry, but he doesn't make any sense. He needs to cooperate with his attorney so that this case can get resolved.
Right. Okay. Well, I will. I appreciate the time of taking this call. I will reach back out with Mr. School, and hopefully, when you guys see each other on Friday, a happy ending can come out of this, and you guys can just put this to bed. 500 days too long.
Well, we'll be dealing with his attorney from here on out.
Sure. No problem. Thank you. You have a nice day.
Thanks. You too, bye.
Okay, that was the 12-minute conversation that I had with Michael C. School's district attorney. After I filed an appearance on the record the next day as amicus, she no longer made herself present in the courtroom again.
Do you have another recording?
I do. Later on, I had to find out and call the recording office and ask what was fictitious about the affidavit Michael C. School filed, and I will play that phone call. And unfortunately, during this recording, it stopped at 6 minutes, and I had to hit record again, and it picked up another 2 minutes of the conversation. So it's like a two-part, unfortunately, on this one, which I'm very irritated about, because I just discovered that on the playback that my phone glitched when I was recording the phone conversation. So give me 1 second here. I'm digging up through my library again. I just had it. That's February 8th. Went too far. I missed it. Where are you at? Where'd you go? There's that. There's the 6. Right. Okay. All right. This is the part A of a two-part conversation with the clerk's office at the recorder's office, where Michael did in fact file the affidavit in question. Talk to, and I'm calling about a particular filing on the record. I have a number.
Okay.
2022001359.
What's your question?
Okay. Is that instrument a fraudulent, fictitious instrument? And if so, why is it filed?
We can't tell you if it's fraudulent or not. We do record generic notices.
Okay.
So, I mean, he prepared the document. We had a document. We had a provision to record it, and we did.
Okie dokie. Because yes, I understand you guys can't give out legal advice, can't answer legal questions. So I'm going to take then at this point the evidence on its face that says the fact that this is recorded means it's a legitimate lien. Otherwise, you guys recorded a fraudulent instrument, yes?
So we don't determine legal sufficiency.
Okay.
What we do is look at the document and make sure it meets recording requirements. If it does, by law, we have to record it.
Okay, so then let me ask you this question. Who does determine the legality, the legality of this instrument?
Somebody with an acronym or an esquire or an attorney at law after their name. We're not attorneys. All we do is go by our document reference and indexing manual.
Okay.
We see if it meets recording requirements. If it does, we record it.
Okay, all right. And forgive me, I'm just trying to get an understanding on how procedures work out there west of the Mississippi. I'm calling from Michigan here, and with this particular lien, there has been a felony charge derived, and the prosecution is claiming that an attorney has already came in and removed it. And it sounds like that's not the case. And my question would.
Okay, so when something's recorded, it's always in our record. So if something else has been done, like through the court or something like that, we probably won't have record of it.
Oh.
All we do is record the documents.
Okay.
So if there's been something done through the court, unless they provide us something that's recordable for some reason, we don't know that there's anything else.
You don't know anything else, right?
People just present us with a document, we record it.
Okay. And just out of curiosity, are you showing any kind of recordings that go along with this that say, hey, this should be stricken for the record, da 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 da?
I'm trying to actually read it.
Sure, right. It's to my understanding, it's a mechanical lien against the client who failed to pay for the services rendered. I believe it was a newspaper article that was ran for about 4 weeks.
Talk about anything like that.
Doesn't talk about anything like that.
No.
Well, that's interesting. I guess I'll have to have a conversation with the drafter and find out what's. Is the name Michael C. School on that?
Oh, yeah.
Okay, all right. Just want to make sure we're looking at the right document. You're very familiar with Michael C. School, yes. He's a very good guy, in my opinion.
We see him a lot.
He's a brilliant man.
You know what? Can I get your number?
Yes, ma'am. It's area code 248 328 5236.
And who am I speaking with?
This is Brian Thomas Coates, very close associate with Mr. School. He's pretty worried right now because of this instrument. He's looking at 3 years in prison, and we're just trying to get the facts here because again, I'm his brother, basically spiritually from the east side of Mississippi, and it's not making sense here. And I did have a conversation with the prosecutor for about 12 minutes, the other day, and
and tell me your concern. I mean, what is it that you're trying to obtain from us, other than the fact that it's recorded? If it's fraudulent or not?
Yeah, if it's fraudulent, because in my mind, and I explained this to the prosecutor, the lady admits he performs work, and she told him, "Sue me if you can." And so he's done so. He's done everything he needed to do, common law, right? But the state is upset because he didn't go through them first, which is kind of like, well, wait a minute. I didn't know there was a law that says you got to take your matters to the state.
I'm going to talk to our clerk recorder, and I will get back to you. I will show her a copy of the document, and
great.
I'll get back to you.
Yeah, I just need to know if there's any kind of standing that says that this is, because, in my opinion, if it's a fraudulent document, it should have been taken off the record. But if it's a solid a document and it has legal standing, then he's not guilty of filing any kind of fraudulent documents.
Okay, let me talk to Natalie, and I'll get back to you.
Great, I appreciate it. Thank you.
Sure.
Bye-bye.
Thanks. Bye.
All right, so that's what happened and why I ended up with the third phone call, 2-minute conversation. She called me back and I hit the record button. So I've got one more video for you to play. That's the follow-up, because she does return the phone call. But I would like the record to reflect that this is now the second California, Nevada State county clerk, prosecutor that is involved in the conspiracy to deprive Michael C. School of his natural-born, God-given rights, United States, blah, blah, blah rights. Straight up, I've never witnessed anything more horrifying in my life. Now I'm going to get forward to the next call here. Give me 1 second. We'll go to the 2 minutes.
Kind of considered like a public FYI. And as far as the other stuff, I mean, like I said, we're not attorneys. That's not our job.
Right.
So, it sounds like it's a determination between Michael and court.
Oh, I agree. Yeah, I agree 100%. It's like, hey, boy, wouldn't it be nice if we could default on our, commitments? If you contract and you say you're going to pay something, I would love to be able to get criminal charges filed against my debt collectors. Wouldn't that be great, right? So,
I mean, the only other thing I could provide you with is what Joe knows this document, as far as reportability goes. We don't know if this document, as far as mechanically, but this definitely does not have the requirements of recording if different. So,
okay.
all I can do is
Yeah, that helps out a lot, just kind of knowing how it was filed and what the extent. If it was criminal and fraudulent, it doesn't sound like it was criminal or fraudulent.
and we would know. I mean, like I said, you look at it,
Yeah.
what's required to record a notice, and record it.
Yeah. So it sounds like he just found public notice and they're trying to make it sound like he could have taken the house from it. And it sounds like maybe he couldn't have because he didn't sign the proper mechanics lien. So great. I appreciate that. That gives me a lot of insight. And I'll be having more conversation with Michael here in a little bit. So I'll be able to bring that to his attention also. So, all right, great. I thank you for your help, Krista.
You're welcome.
Bye-bye. Okay, that ends the majority of the most important recorded phone conversations I've ever had in my life.
Thank you, Brian. Does anybody have anything they'd like to discuss now? We've heard a lot of stuff. We should have some thoughts. If we do, we should present them here. Brandon.
Yeah, I just had a thought as he was playing the recordings and discussing what had occurred. It dawned on me that maybe that guy who did win his court issue or seemed to have gotten it dropped up on Washington when we had a assembly call a few weeks back, that might be of use, the demanding a court of law and equity or to drop the case. I yield.
Have you done that, Mike?
Uh,
Have you demanded of them that they provide their bona fides?
I did a notice or request for a bill of particulars, and that's in the long email I sent you this morning. You said had like 80 pages.
Yeah.
But they ignored everything, and California doesn't offer equity.
Michael, I have a question for you. Did you tell me that the judge threatened to commit you if you didn't shut up?
Oh, yes. And when she's saying I said I was an idiot, it's because it was supposed to be they had a special surprise hearing. They changed all the calendars and they vacated 5 court dates and then had this special calendar and reoccupied one of the court dates, trying to confuse me. So I showed up, and it was a competency hearing. They were going to commit me to a mental ward. And that's why I said I'm an idiot in your court, because an idiot is not allowed entry into the United States. So she's only giving you partial statements on that recording.
Michael, I have another question for you. Did you complete the job?
I completed, well, the job was 95% complete. We had to pour concrete, like I was saying, to be able to set a plate to reframe the opening, which the original estimate was for her to buy a door, which it's normally a fiberglass door, but she bought this door that was like 3 times as heavy. And that's why I had to call Luke, who's sitting next to me right here, to help me unload it, because it was so heavy and it was hurting my back. So all that was left was to caulk the inside frame, patch a little bit of floor, and reinstall the blinds. So I dedicated 2 days of my own time for free to do this to her. And that's when she baited me and attacked me and told me, get out of my house. I'm not going to pay you. She said, you think you know law, go sue me. And I found out later through a third party that her daughter works for the attorney who's representing her.
Okay. Another question that the prosecutor, from her own accusation that you filed eviction. Did you ever file anything further into any kind of court of record outside of the recorder's office that you did file whatever instrument it was that you filed?
I did a complete administrative process from conditional acceptance through notice of default and estoppel, and they granted a restraining order against me, but omitted my affidavit from the record because the judge was colluding with the attorney.
Let me articulate. Did you file for an eviction?
No.
Okay. Let me see. Any other questions that I think I might have for this record? I don't think I do, because I've been, well, did you in fact verify? Let me ask you this question. I'd like the record to also reflect. Were you able to witness that clerk of courts did in fact receive a fax from me as an amicus entering this court of record?
Yes.
What did you observe when you tried to get in a certified copy?
I think that was one they removed too and returned to me, wasn't it?
I can't tell you what to say. I got to ask you the question.
I believe that you sent me
to get a certified copy, and you had trouble getting the first original copy. What was the reason that you could not originally get it when you were there first in the morning? Why did they tell you had to come back?
Oh, because the clerk of court was sitting on it, and they played games with me all day, and then they finally said no, I couldn't have it, and they never gave it back to me. So they're still sitting on your fax, although they denied that you could help me as assistance on the record.
Right. So again, can I ask you maybe where they might have told you why it was you could not receive access to inspect and receive a certified copy as required as a court of record public?
Okay, Brian, you have to wait now after Mike answers that, because we have 3 people with hands up.
They've bait and switched me so many times, Brian. I don't remember the answer to that question in the moment. Sorry. But I never got the certified copy of it because they were sitting on it.
Eric, you have a question?
Yes, I do. Mike, what would it take to end this thing? I mean, has that ever been discussed? Like, what's it going to take to make this all go away?
Well, originally, if Maria would have just acted in good faith, she said you won't give me the receipts. and I had all the receipts, and she rejected them, and she told the prosecutor that I've never provided receipts to her showing that I spent the extra money, and she testified in court that she provided all the materials and that I didn't have to buy anything, which was untrue. So Jim Butler is the third witness. He testified in court that he made all the materials runs because he had a truck at the time. I only had a car. So he picked up the materials, the concrete, and then he had to make an extra trip because she changed the scope of work after the outside trim was installed. And she wanted it changed to a Japanese style cut, which means we had to go get a board that was a foot longer for the overlap.
But what would it take to make this all go away at this point in time? I understand what happened in the past. I understand where you're at right now. Has there been any discussion about what it takes to make this go away? Because this seems awfully overblown for something really that should have been, as we've discussed, you're taken care of in small claims court.
Originally, after the restraining order hearing, they charged me with the felony. I was arrested. They appointed me counsel. The counsel told me he could get it dismissed, so I agreed with them. He threw me under the bus. He told me that the prosecutor already offered to dismiss it if I dropped the land claim, and that they would bring it up at the next hearing. So at the next hearing, I approached the prosecutor and said, "Hey, can we discuss? I'll drop the land claim and you drop the charges." And he said, "No, I've been instructed you have to be prosecuted." So they withdrew the offer to settle everything.
And for the record, at this point, Michael has been found guilty by a jury of his peers. We are beyond tap out. Michael is a convicted felon, illegally, unlawfully, and corruptly, maliciously, in violation of California Penal Code 1181.
Thank you, Brian.
Title 18, 241, and 242. I am a witness.
Hey, just one other quick question. Michael, why do you think they're after you? Is there something else that you think may be an undercurrent here that's driving this situation?
Yeah, I've been very outspoken as an activist and patriot for 12 years in this county. I've exposed corruption ever since I moved here. And when I first moved here, a deputy showed up at my gate, and I went down to see what was going on because I didn't have any issues with anybody back then. I was just a contractor with two little kids at home. And when his first words to me were, "I can shoot your dog anytime I want," and that's what I was like, "What?" So I did a grand jury complaint on it, and then I met a grand juror up here, and she taught me how to do grand jury complaints for real. So I started investigating the public officials because I discovered the corruption. But what it really is there's an attorney up here that's part of a child. He's a pedophile, and he was exposed up here, and it wasn't by me directly. I just became aware of it in front of a group of people, and he's been targeting me and the other people that were in that conversation ever since. So he shares an office with Maria's attorney. You have to go past his door to get to Maria's attorney's door. So I believe that they're acting in combination to suppress my rights because I'm due for sentencing for 3-year state prison on March 18th, but on March 20th, I have a custody hearing where they're going for 100% custody for my ex. So I believe that they spoke about all this beforehand to lay their plan of action.
Thank you.
Laura?
Yes, hi. Thank you for your story, Michael and Brian. I think this has been answered, but I'm kind of new at learning what I can about our law, our rights. I want to know what specific paperwork was set up to claim her home. Is that the land claim?
Yes.
And that's what you're charged with felony for?
Yes.
And that's her fear that her home was going to be taken away. So that's part of her energy going into this part. But I totally agree. I think you're set up for sure.
The deputy, there's an audio conversation that between me and the deputy that he didn't tell me he was recording because he just called me out of the blue one day, and I don't have anything to hide. So I talked to him and I offered him, "Hey, if you want, I'll email you everything I got." And he said, "Okay, thank you." And when we ended the call, he said, "I'm closing out the file as information only because this is a civil matter." And he told me at a later hearing that he was somebody went over his head and told him that this has to be prosecuted.
Yeah. They have you in their sights for sure.
Yeah, but he knew that I was doing an administrative process, and that I had filed the public notice in the paper as required by law. I complied with the county clerk recorder's requirements because they rejected the filing multiple times because of the cover sheet. It has to have a specific format, and it has to be notarized, and you place it in the newspaper, all that stuff. But the deputy was also aware that to complete the administrative process, it would still have to go before a judge. So it's an incomplete, invalid process without a judge's approval. So the prosecution is just harassment.
Right.
Brandon?
Yeah, I'm just curious with regards to the amount. Is that what led you to not go through small claims, or do you mind if I inquire as to why it is that that was not done first?
In this county, we filed. So I filed liens. I studied statutory law first because I don't want to break the law. I was a general contractor for 16 years. Uh, the courts here, the attorneys will throw cases for other attorneys, and there's no justice. There's nothing you can do. Nobody to report to. So the two liens that I filed, the attorney had them removed without serving me notice, and a judge signed off on that. So I knew that was an invalid process. So I spoke to somebody in Michigan, Harold Petrie, who was a common law professor, and he's the one that suggested the land claim, which is why I pursued that, because it was in common law, which is superior to statutory law. But I didn't know at the time that California had abolished common law as a rule, basically.
That goes back. Okay, so
And in the small claims court, it's the same thing. We did sue an attorney for fraud up here, and the judge kept ruling for the attorney and suppressing our rights. And they just basically, when we got to the appeal, they threw the case. And that was for an 87-year-old man up here named Jim Butler that was he was swindled off of his title to his land, and his land is worth $1 billion in gold. So that's related to this case too, because I help him.
Sounds like you have a hell of a target on your back, Michael.
Yeah.
yeah, I also want to say that you guys brought up a pretty valid point that should be brought to attention. Have you guys attempted to let them know that you're aware that there's a conflict of interest with the lady who is the homeowner having somebody that is part of their system?
They're already aware of it, because okay, so Maria's attorney was the actual complaining witness, which was omitted at the probable cause hearing. Maria was presented as the complaining party, so that was a false statement. And then her attorney he wasn't there and never asked to testify. So he was when they vacated my trial dates and reset them, they set it for dates that when he would be out of town, so he couldn't be called to testify. So I've never cross-examined him, and I've only been able to cross-examine Maria one time out of 4 opportunities I should have been given.
Michael, were you during your juror trial, did you ever get an opportunity to present evidence or witnesses to your favor and get the witnesses to testify on your behalf in front of a jury of your peers?
I was only allowed to have 2 people show up, and that was Luke and Jim, because they worked on the job with me, and they had direct testimony, but they were only allowed to give character statements on my integrity.
Did you make an attempt to subpoena the state recorder's office clerk?
Yes, Luke took a subpoena over to Krista, asking her to come to court, but the supervisor would not let Krista come forward to accept it, so she didn't show up for court. But she was aware of the subpoena.
Okay. Was there a question that the jury asked the prosecutor?
Yes, the question they asked the prosecutor was, what is fictitious about the document? Because when you read it, it says that it was filed under the let me refresh my memory. Okay, so it says declaration of claim within the laws of the Constitution for the United States of America for this property. So did I answer your question?
I think I asked the question of what the jury wanted to know as far as about your instrument, and then I had a follow-up question to ask: do you feel that Krista's testimony would have been able to answer that question that the jury asked?
Oh yeah, because Krista stated that it's not a deed, it's a notice with no enforcement on it. So her testimony could have directly rebutted that the deputy made false statements.
Do you feel the jury may have found you not guilty?
Yes, they were goaded by the prosecutor. Your first question, you said what was their question? They asked what was fictitious about the document, and the prosecutor changed the parameter because it said before that you have to find him guilty. He had to knowingly file a fictitious instrument. So the jury said, "What's fictitious about it?" So he took that opportunity away and changed it to mistake of law. If Mr. School filed the document and we told you it's fictitious, then you have to find him guilty.
Oh,
Laura's up next.
yes, that one got me. Thank you. I want to know a little bit about your process for your jurors selection. We've been through one of those and we saw really bad things happening in regards to that. So I want to hear yours. A jury of your peers. Did you have any?
No. They were sworn into a de facto oath that wasn't to the Constitution. It didn't say "so help me God" either. And they were instructed that they will have to basically rule according to how they're instructed by the judge.
Yeah, sorry.
So I
Yeah.
brought that up to the judge. This is not a jury of my peers. You're within the United States, and I'm in the United States of America. And she said, "You're wrong. This is all the United States. There's no two. It's only one." And she also denied that they were a corporation on the record. So I read their Dun and Bradstreet number into the record.
Mike, I got a question for you.
Yeah.
I can't find anywhere that any state can make any law that is against the Constitution, and you are required to have an Article 3, Amendment 7 court of record. Now, that's written. I don't know how they can try a body, mind, spirit, flesh, blood, soul in their court and tell you that there's no equity in California and no common law in California when it says that California's laws cannot contradict the United States of America's Constitution. I yield.
In the 81 pages you were referring to, that covers what you're talking about right there, directly with my filings. I did request 7th Amendment trial by jury, any amount in because we spoke, remember, and I put down verbatim what you told me to state. I also did the Article 3 court of record, and I notified them that the state of California is an inseparable part of the American Union and bound under the laws of the United States of America, and they denied it. And
gave you all the documents back.
They returned all my mailings, and I have one here that I don't know if you guys can all see this one, but this is a copy of the package that was rejected and handed back to me in court. And so the court, this was refused by the clerk of court, and they've refused 4 of these. So these are all my records requests for official documents, transcripts, things like that, oaths of office. I don't have anything. I don't have any discovery, and that's why, because they were refusing everything. But I reported it to the sheriff's department because this is mail fraud, and they told me that mail fraud from me is a civil matter, and they can't deal with it.
And can I make a note for the record? All of you have witnessed prosecutor confess with her own mouth to me on that 12-minute conversation that Michael C. School had filed 1099 liens worth $20 million, making lawsuits against every one of her personnel in her office. And it was obnoxious. It was not unlawful. It was not illegal. It was not malicious. It was obnoxious. Let the record reflect that, please.
Thank you, Brian. You got to wait your turn, Brian. Brandon?
Can you have someone on your behalf bring that document that they returned to you to the court in person and have them stamp it, showing that they've received it and filed it with that court, and then also go forward and file a complaint for judicial misconduct on that judge?
Nobody will accept my complaints. They just reject them as without merit and throw them away, basically.
Okay, I'm sorry to interrupt. I need help with my screen because you said wait my turn, and I only see myself, a mountain, and the number 8 on the screen. So I don't see anybody else know that I gotta wait my turn. I'm sorry to interrupt, but can somebody help guide me on what button I gotta push to see how it is I wait my turn?
Are you on a phone?
I don't see anything on my screen except a
Are you on a
BK.
phone device?
Yes, I'm on a Galaxy cell phone.
On the bottom right corner, there's 3 dot button for a menu. You can
Okay.
press that, and then on the bottom left, just above close, you'll see raise hand, and that'll allow you to raise the hand.
Okay, how do I know if other people have their hand raised? Because that's what I don't see. I don't see anybody.
You don't
the
have to.
moderator or somebody calling on will see which hand went up first and call in order. I yield.
Okay, so I just raised my hand. I'm sorry, I'm new to Skype. I've never used it before. I'm sorry.
That's okay.
I'm
Bobby,
gonna
it's your turn.
I was just going to say that what you just said, Ron, was exactly what I was about to bring up. California cannot go against the federal Constitution. They have to abide by the federal Constitution, not the corporate Constitution, but the real one. And if they're saying that they don't have to, there should be a pretty big issue there because they have no choice. That's how they got in the union in the first place, was to agree that all their laws have to be compliant with the federal Constitution, the original. I yield.
I did bring that up to them, that federal law trumps state law, and they're bound to the federal constitution and then the state constitution, and that state law has to uphold federal law to be enforceable, and they denied that too. So I challenged jurisdiction at the last pretrial conference. The judge told me that the prosecutor will have to prove jurisdiction on the record because I quoted Title 5 USC 556D of the Administrative Procedures Act. And Higgins versus Levine, that proof of jurisdiction of the agency must appear in the record prior to the commencement of the proceeding. So the judge made her statement, and then at trial the next day, when I brought it up, she said the prosecutor has jurisdiction. You're in Nevada County, and then they just moved forward and ignored me after that. And anytime I raised an objection, I was taken into chambers, and then the objection was denied and not entered into the record.
Brian,
Jeez.
I see your hand up, Brian.
Okay, I think I'm getting the hang of this. My apologies for cutting anybody off. I didn't know the gist of Skype here, so I got it now, though. What I wanted to point out, though, with talking about the federal and how Michael filed, and the judge is basically saying, we don't have to in the federal. It's going to be interesting because as we move forward and he has to go register for the probation, he's going to be required to adhere to all federal law. Now, imagine that. They're going to make Michael observe federal law, but these guys will not, in fact, observe federal law themselves. I'll yield.
What I see is you've been railroaded, Mike, and I don't know what the hell you can do other than what Michelle said. And you're right there where the 9th is, probably within 50 miles of it. I'd get something written up and I'd get it filed into that court Monday morning.
Into the 9th Circuit?
Yeah.
It's Michelle, may I?
Sure.
Yes.
I will forward you the notices. What is your email address, Mike?
My email is dejuremike@yahoo.com.
With an E on the end, DEJURE.
I'll drop it in chat for you.
MIKE.
Yes.
Okay, thank you.
At yahoo.com.
Okay, yeah, you are welcome to use these. You'll have to change, fit it to your personal details, but you just have to be really unrelenting and point out the facts and because they can't deny anything. The Ninth Circuit has to respond. Okay,
Yeah.
so anyway, I won't take up any more time, but I will forward you what two of the people that I've been working with that they've used. Okay.
Thank you, Michelle.
Thank you.
You bet. You're welcome.
Bobby, your hand's still up.
How do I take it down?
Okay, I don't know. Brandon, how does he take his hand? Oh, you figured it out.
Well, I just hit
Brian?
it again. Did it go down?
Yeah, it went down.
Oh, I just hit it a second time.
Brian?
Okay. Yeah. So I mean, I guess I'm over here on the east side of the Mississippi, and I've got some experience in the common law. Michigan is a common law state. They still kind of tinker around with it a little bit, but it's fading out. Of course, they're all falling in line together. But I have experience with an appeals court case with my wife that we were involved with. That's how I met Michael C. School. And that's how our friendship was built into a brotherhood. So, with that being said, I'm only limited to the knowledge of how to kind of wiggle your way through some court of record with the appellate court. I've got a little bit of experience on that. That's about as far as it goes. But I need more eyeballs on my brother here, and I just hope you guys will help me keep an eye on him as we move forward with this. Is all I'm asking, because I think I think I'm done here with the Skype conversation. I don't really have anything more to ask. My witness is good. I mean, you guys are west of the Mississippi. You're in Oregon. That's right above California, and you guys know how to operate that court system probably a little bit better than I do, even though they're all supposed to be the same. But right now, really where it's at is to continue just pressing forward and also covering his ass on appeals and shit like that, just to make sure the guy doesn't disappear in the system.
Thank you, Brian. Laura?
I kind of want to apologize for my question, but I have this thought in my head in regards to this. If Michael's going to write to the Ninth Circuit, that will take some time to get an answer back. We've seen that. So in meantime, he's got to meet a date that's coming up middle March, if I remember, middle March.
March
That
18th.
yeah. What can we do to keep him out from jail?
As soon as he gets his documents filed into the 9th, he'll have copies of it, and he takes that right back to the Superior Court in Nevada County and files that into their record. It's going to be really, really tough. He's already convicted. So I don't know any way out that I know of other than to just keep going forward. And the next step is the 9th, and doing the best you can there and taking that document back to the Superior Court. And I yield. Brian?
Okay, what I learned from my wife's fabricated conviction and having to grab the key by myself with no help to open the door to the appellate was immediately after the jury has reached its verdict, the defendant has 14 days, and this is a procedural rule, has 14 days to file Federal Civil Rules 29, set the verdict to the side pending an appeal, because the outcome of the appeal may change the event of the course. Now, instantly,
Thank
that
you.
will be denied at the trial court. It will be denied. However, that is the key that opens the door to say, I appeal, object, finding of fact, conclusion of law, and it immediately moves the jurisdiction from the small petty-ass trial court and puts it up into the appellate court, and then they can release him on a bond. I was able to pick my wife up from prison with a $500 bond by myself. I did it. The appellate court called me before they called her snow job attorney, because when I snapped that record so damn hard with the paperwork I filed, which is really crazy, They shut me up, struck it from the record, had her new appointed appeals attorney call me and said, just relax, she's coming home. We just got to let the process work its way out. So that's what happened. My wife had to go to prison for 27 days, but then by the grace of God, her conviction was later overturned and every peasant paid for it that did the wrongful conviction. That's the short story end of it. But that's to tell you what the process is on a procedural level. Okay, that's what has to happen. 7 to 14 days is the window that he needs to get a key filed right back on that corrupt record.
Yeah, Monday morning. Monday morning. Do we have any more that we can do here? Mike, do you have any more you want to say?
I did a 1099 on the prosecutor for the amount of the warrant, which was $20,000. But I did an administrative default process under Title 15 against the prosecutor for lack of subject matter jurisdiction. And under, I think it was 15 USC 78 FF, there's a $25 million penalty for fraud. And that's what she's talking about. So I defaulted them for $25 million, and that's why they refuse to let it go now, because I've already completed the subject matter administrative process.
Include that with your paperwork to the 9th.
Yes. And it was all in the it's all also based in these the rules of court that I showed you earlier.
Yep.
Inside of this, I have a process for a 1983 injunction, and so that's where I got this stuff out of here. So this is something that the prosecutor is sitting on, and the judge, and they told me that this is in the record, but they refused to file it. And I don't know if you can see it.
We can't make it out, but we know you got it.
It says affidavit in support of motion for default judgment. And it's notarized because I sent them the follow-up affidavit of default after they defaulted the first time. I gave them an extra 30 days. So I don't think in federal court they really have a leg to stand on, but I don't know how to do all this stuff, and I'm just kind of under the gun from multiple issues, really.
Michelle's going to get you that today by email.
Okay, thank you, Michelle.
I'll make sure that she's got your
You're
correct
welcome.
address.
Okay.
Yeah, this is gross judicial misconduct.
Yeah.
Yeah. Major racketeering.
Is there any more we can do now? Brian's got his hand up again.
Yeah, what I definitely found based off, with all the conspiring and the snatchings of the record, California has a state penal code 1181, malicious prosecution. It absolutely is a felony. And this is absolutely fits that penal code. It literally violates their own statute.
They do it all the time, Brian. Every day, all the time.
Yes. So that's the standing of complaint. I believe we have the evidence. Just need
I
the
believe so too. I believe so too. But I don't think we can accomplish any more here right now. So I suggest that we close this and move on. Michelle gets the paperwork. Brian's got paperwork that Michael has or needs to see. And Mike knows how to get a hold of me, and we'll make everything happen to the best of our ability. You're in a tough way, guy.
I appreciate you guys' time.
Keep the faith. Stay strong.
I have one last
that's what they try to do is break you. That's their goal, is to break you.
Yes.
Will somebody close this with a prayer?
Yeah, Brandon had his hand up, first of all.
Yeah, I was just going to ask, when is your next court?
My sentencing is on the 18th.
Okay, we will be sending prayers your way.
So Brandon, would you please offer a closing prayer?
Yes. Father, this afternoon, after meeting and listening to what Michael is going through, the trials and tribulations that are occurring currently within the state of affairs concerning our courts, and knowing and us being aware of the fraud being placed on the people going through their system. We just ask that you guide him in all his ways and that you allow him the opportunity to have a way out. While we may not be able to see it at this time, we just ask that you guide him in his heart and give him faith and allow him to know that you have a bigger plan for him, whatever that may entail. And we just ask that you give him that faith to walk in the direction that you so have chosen for him. And we thank you for this opportunity to be able to meet with him and be able to have a meeting of the minds and discuss and try to come up with solutions. And we just know that you will provide those solutions at the right time. We will continue to pray for Michael as he goes through this. And we pray all this in your son and our Savior Jesus' name. Amen.
Amen.
Thank
Amen.
you. Thank you, Brandon.
Stay strong, Michael.
Thank you,
Yeah,
Brandon.
our prayers are with you.
Thank you.
Nice meeting you guys. Love you. I'm signing out.
Thank you.
Good job.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car. And he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.